Hi there, welcome back to the latest instalment of ReguLaw. I'm Beth Hale, I'm a partner at CM Murray. In today's episode, Andrew Pavlovic and I are really delighted to be joined by Chole Carpenter KC from Fountain Court Chambers. We're going to be talking about the approach that regulators take to criminal offences, where those offences arise from conduct outside of their practice. We're going to be focusing on a recent decision of the High Court and talking about the sort of wider issues around that case and what issues those kinds of cases throw up in practice. Chole is recognised in the legal directories for her expertise in regulatory and professional discipline matters. She's acted for both the SRA and respondents in some of the largest cases to come before the Solicitors Disciplinary Tribunal, including acting for the SRA in the case of SRA and Maine, which is one of the cases we're going to be talking about today. So we're really, really pleased to have you here, Chole. Thank you for joining us. Andrew, if I can ask you to get started, some people would say this is a massive overreach, isn't it? Why do regulators care about criminal offences committed outside of practice? What does it matter to them?
Well, I think there's two answers to that question. The first is where the criminal conduct directly relates or indicates that someone might not be fit to practice. So, for example, solicitors, barristers are officers of the court. Solicitors have access to client money. So if someone's convicted of a criminal offence involving dishonesty, that's likely to be taken very seriously by the regulator because it might suggest that they're not fit to be in a solicitor's practice at all. And then a rung down from that, perhaps you might have conduct which is not dishonest, but could be reckless, and which could breach the requirement to act with integrity, which has been defined as sort of the higher standard that society expects from professional persons. So you have those sorts of cases where the conduct suggests that there could be a regulatory risk arising from this person remaining in practice. And then you have sort of the second limb, which is criminal offences which might not be at the more serious end of the spectrum, but where the regulator considers that some sort of regulatory action is still required to uphold public trust and confidence in the profession. So the SRA guidance on criminal offences states that they consider that the requirement to maintain public trust and confidence in the profession is likely to be breached by the commission of an offence. So depending on what offence we're talking about, it could be a relatively minor sanction, such as a rebuke. But they'll usually consider that some form of sanction is merited. And one of the things that we see very commonly, for example, is offences such as drink driving. That was a big sort of hoo-ha about that recently because the SRA had introduced incomes-based fines and solicitors were being fined large amounts of money, but they've now sort of seen sense. And you quite typically see solicitors being rebuked for offences of drink driving where there's no other sort of aggravating factors.
Not that we'd condone drink driving, obviously. And Chole, can you tell us about the case of SRA in Maine and the sort of key principle or principles which derive from it?
Yeah, so the case of Maine is Mr. Maine was a solicitor who was convicted in the magistrates' court of sexual assault and racially aggravated assault, both against his ex-girlfriend. He'd seen her at a bar and had assaulted her there. He was sentenced by the magistrates to 12 months community order and also a 5-year restraining order restraining him from contacting her was imposed. Because he got a community order of 12 months, that meant that he was automatically placed on the sex offenders register for 5 years for an offence of sexual assault. So the SRA brought disciplinary proceedings against him for alleging lack of integrity arising from those convictions and alleging failing to uphold public trust in the profession as a result of those convictions. And he admitted those two allegations. And the SDT, the Solicitors Disciplinary Tribunal, decided to suspend him from practice for just under 1 year. And the SRA appealed that sanction as too lenient and argued that a longer suspension should have been imposed. And I acted for the SRA on that appeal. I relied in the appeal on a case called Fleischmann, which was a case from another regulatory scheme, which essentially held that there's no bright line rule, but that generally a professional should not be allowed to practice while serving a criminal sentence. And I also argued that the SCT had erred in law or had made an error of principle because it hadn't asked itself what I said was a key question, which was, in coming to its decision on sanction, the key question I argued it should have asked itself was, would public confidence in the profession be harmed if the public were to find out that a solicitor with recent convictions for sexual assault and racially aggravated assault and who's on the sex offenders register is able to practice? and the administrative court allowed the appeal, overturning the SDT's sanction. The administrative court agreed that the Solicitors Disciplinary Tribunal had failed to ask itself that key question, and that there was only one answer to it, namely that public confidence would be harmed by a solicitor with these recent convictions for sexual assault and racially aggravated assault, and who's on the sex offenders register being allowed to practice. They replaced his sentence of suspension with a 4-year suspension from the date of the SDT's hearing. So, and I think the main principles arising from it are that although the Fleischmann case, i.e. generally a professional shouldn't be allowed to practice while serving a criminal sentence, should be taken into account, it's not a bright line rule. In fact, that decision had been taken into account by the tribunal. And the key reason for the administrative court's decision was that my second argument, that they'd failed to ask themselves that key question, whether public confidence would be harmed by having a solicitor practicing with these two recent convictions, and who's on the sex offenders register.
If we move on to the recent case of Hickey and the Bar Standards Board, can you tell us about that decision?
Yes, so that related to a barrister who was involved in a road traffic accident where the other driver was killed, and he was prosecuted for dangerous driving and sentenced to a custodial sentence of 23 months. And as he behaved impeccably in prison, he was released on licence after 10 months to serve the rest of his sentence in accordance with his licence conditions. So the Bar Standards Board took action against him, and they alleged his conduct breached Core Duty 5, the requirement to uphold public trust and confidence in the profession. And they suspended him until September of this year to coincide with the end of his licence, the end of his sentence, effectively. And they relied on the case that Chloe just mentioned of Fleischmann to say the practitioner who's convicted of a serious criminal offence should not be permitted to resume practice until the completion of that sentence. So Mr. Hickey appealed to the High Court, and Mrs. Justice Dias overturned the BSB's decision. And she said the BSB had applied Fleischmann as an inflexible rule instead of doing what Chloe said and sort of looking at the facts of the case and reaching a just and proportionate outcome. And if they had looked at the facts of the case, they would have taken into account, for example, that he'd already served a period of interim suspension whilst the criminal trial was ongoing and the criminal proceedings were being dealt with. In relation specifically to public trust and confidence, the judge accepted the submission that the general public would not reasonably expect barristers to observe higher driving standards than anyone else, and that when taken in the round, it wouldn't diminish public trust and confidence in this case for him to return to practice. This was not a case where it was a tragic accident and he had been driving dangerously, but this wasn't a case which involved drink or drugs. He'd shown remorse, considerable remorse. He had references, he had self-reported, he'd done everything that he was supposed to do from a regulatory perspective. And there was no risk to clients arising from his conduct. So she actually set aside the BSB's decision and said no order was required because the period the suspension that he'd already served, the interim suspension whilst he was awaiting the outcome of the criminal proceedings, was sufficient.
So that's a pretty different sort of judgment. I mean, I can see that the offences are different, but Chloe, can you just talk us through how you reconcile the Hickey case with the main case? And do you think that Hickey is right in circumstances where, given the case in Maine?
Well, the case of Maine doesn't appear to have been cited in Hickey. At least if it was, it's not referred to in the judgment. But the judge does refer to Fleischmann. I think the key difference between Hickey and Maine, the decisions, is the nature of the offence, as you just mentioned. So whilst Mr. Hickey's driving was dangerous and obviously had the worst possible consequence being a death, his moral culpability was much lower than Mr. Maine's. So Mr. Hickey had made a momentary, albeit dangerous, error. And so the judge considered there was no moral turpitude in Mr. Hickey's case. Whereas in Mr. Maine's case and in the Fleischmann case, so cases of sexual misconduct, for example, sexual offences, those are cases of moral turpitude. I think my view is that the High Court was right to overturn Mr. Hickey's suspension of nearly 11 months. Because I don't think it was right. I don't think the disciplinary tribunal were right to say that Mr. Hickey was still serving a criminal sentence when he was on licence. And even if he was, as I mentioned before, the Fleischmann principle is not a bright line rule. And I agree with the administrative court's decision that the judgment of the disciplinary committee wasn't sufficiently reasoned as to why did they think that the Fleischmann principle applied in this particular case on these particular facts. So I do agree with allowing the appeal in Hickey, but I don't agree with everything in the administrative court's judgment. And it's worth saying that I think the judgment was extempore and has been transcribed. So it's fair to note that. But for example, I don't agree with the decision that there should have been no order at all against Mr. Hickey because of the interim suspension he'd already served. He'd been suspended on an interim basis from the 8th of November 2024 to the 4th of November 2025. But of that period, he was in custody for most of it, from 1st of November 2024 to 7th of July 2025. And so he couldn't have practised anyway. So the real interim suspension when he was out of custody was about just under 3 months. So I personally think no order is something I wouldn't agree with. I think the right order, to be made by the tribunal, would have been one of either a fine or a further short suspension, maybe something in the order of 4 months. And that would have been, if the administrative court had imposed that on appeal, that would have actually already been served by the time of the appeal. So it would have been a time served order. So it wouldn't really have affected what happened to Mr. Hickey, but I just think that would have been the correct approach in principle. I also disagree with some of the reasoning in the judgment. So, for example, it talks about Mr. Hickey being considered fit to live and work in the community normally, and that being the view of the criminal authorities. But my understanding is that going on licence is something that happens automatically at a certain stage in a sentence. I don't agree with the suggestion that any part of his sentence was a nominal sentence, criminal sentence. And then at paragraph 48, the judgment talks about the general public has no legitimate expectation that barristers will observe higher driving standards than anyone else. And I think that's obviously right. But I don't think it's necessarily the full question, because I do think the general public has a general expectation that lawyers will abide by the law.
I think that must be right, mustn't it?
And I think that we are held to a higher standard in complying with the law. And so I wouldn't necessarily fully agree with the way it's put at paragraph 48. So I agree with them overturning the appeal, but I don't agree with every detail in the judgment.
Yeah, it's interesting, isn't it? Because I totally agree with you that, yeah, when you put it like that, yes, I agree. If you said to someone, do you think a barrister should be a better driver than any other member of the public, I think everyone would say no. But it's a different question, isn't it? Do you think that a barrister ought to comply with the law and not break it? I think most people would say, yeah. Anyway, it's interesting.
I think it's also relevant that he was given a custodial sentence because he'd been fined or caught speeding on previous occasions. So there was a history of speeding or reckless and dangerous driving. And that was why the court felt it had to give him a custodial sentence in the first place. And again, it's obviously very tragic and in some respects unlucky, but it also, you could argue that there was a history there. And obviously lots of people get caught for speeding. So we're not sort of standing in too high a form of judgment, but I think that comment itself seems to be quite unfortunate to me, and doesn't really reflect the gravity of it.
Can you talk to us a bit about other regulators? What approach do other regulators take to these kinds of issues? And thinking particularly about the FCA.
Yeah, so I was just going to mention the FCA case of Frencham, which is quite well known and relatively old now. It's a 2021 case. He was convicted of a sexual grooming offence under the Sexual Offences Act, and the FCA made an order prohibiting him from performing a regulated activity or function, and he appealed that order to the upper tribunal. And this appeal was heard following the Beckwith, just after the Beckwith case, which I don't sort of propose to talk about again because lots of people have talked about it for a lot of time. But Frencham essentially argued that the FCA had failed to establish the connection between his offence and his ability to perform a regulated activity. And the upper tribunal actually agreed with him on that. and they said that they hadn't established a link between the offence and his ability to perform a regulated activity. The nature of the work that he did, how would this actually impact on his ability to provide his services? Ultimately, they did, though, uphold the decision based on the fact that Mr. Frencham had failed to self-report or bring any of these matters to the attention of the FCA until the FCA had found out about them when they'd been reported in the press. So the decision stood, but there was a lot of criticism generally of the the FCA's approach. And interestingly, in relation to public confidence, they observed that the conviction had been widely reported and that Frencham had been open with clients when asked about things, and apparently only 30% of his clients had gone elsewhere following the conviction. So perhaps the public aren't as bothered about all of this stuff as we and the regulators think they are.
Yeah, absolutely. Chloe, do you think that the outcome of that case would have been different if it had involved a solicitor or a barrister? Going back to our earlier discussions about the different approach by different regulators.
No, I don't think so. I think that, not the point about whether the decision would be criticised by a higher court, but just in terms of the decision to remove someone, I would think that the Solicitors Tribunal and the Bar Tribunal would be likely to end someone's right to practice. So either strike off or disbar someone for that level of type of criminal offending involving children and of that nature. But obviously each case turns on its own facts, but that's what I would anticipate would happen.
Thank you. And just thinking about criminal offences and professional obligations, what are solicitors, Andrew, required to report to the SRA in relation to criminal allegations? When do we have to tell the regulator, and at what stage?
There's a requirement to notify the SRA promptly if you are cautioned, charged or convicted. But then sitting alongside that, you have the more general reporting obligation to bring facts or matters that you reasonably believe are capable of amounting to a serious breach to the SRA's attention as well. So there can be, in some cases, a bit of a tension there. So you might have been accused or arrested. You haven't been charged, so you haven't met the requirement to notify the SRA of the charge, but are you still caught by the wider self-reporting obligation? And in relation to sexual misconduct, for example, the SRA guidance says that it may investigate matters even if the police have decided not to take action. So the fact that the police decide not to charge you after investigating doesn't necessarily answer the question. And in fact, there was a recent sexual misconduct case in the Solicitors Disciplinary Tribunal where the respondent had tried to argue that his conduct had effectively taken place outside of practice. It had taken place in someone's home after a party, and it wasn't sufficiently proximate to practice. And the SRA argued that sort of any non-consensual touching, whether it was connected to practice or not, could justify regulatory action from their perspective. So it is actually not as straightforward as you might think in terms of, okay, I can just sit back and wait and see whether the police are going to do anything. And just as a practical matter, the SRA and the police do have what's called a memorandum of understanding pursuant to which they can share information. So it definitely requires some thought if you're in one of those positions, even if you completely deny the allegations and don't consider that you have committed a serious offence, because the test is sort of framed in a way which just contains an objective element. So it's not as straightforward as you might think.
No, people should be coming to you for advice, right?
Oh yeah, I mean, I've got a vested interest in saying it's not as straightforward as you might think, but it generally does require a bit of thought.
Absolutely. Chloe, we've been talking about criminal allegations for the purpose of today, but just to broaden it out a bit, what about sort of non-criminal allegations relating to conduct outside of practice? Is that where something falls short of being a criminal offence, but is still potentially problematic?
Yes, I mean, one example is what Andrew just mentioned, which is some of the sexual misconduct cases are not either not criminal offences at all, or criminal proceedings are not brought in respect of them, even if they could, in theory, amount to a criminal offence. And you have some cases of alleged sexual misconduct where there's actually a dispute about whether it falls within or outside of practice. So, for example, sometimes things take place at work parties or with work colleagues, but not at work. And then there can be a dispute. Well, is this work related or not? But in any event, firstly, tribunals usually take the view that if something happens with a work colleague or at a work social event, that is related to practice. But in any event, as Andrew mentioned, in any event, this regulatory scheme extends at least to some extent to non-criminal conduct outside practice anyway. Another example is a recent case called BSB and Stenhouse, where a barrister was involved in litigation, which sounds like something barristers do, but it was actually his own litigation. He was a party to the litigation. So he was in a dispute with HMRC over his own tax affairs. And so they were engaged in litigation in the first tier tribunal. And in the course of that litigation as a party, he wrote correspondence that accused HMRC of making secret submissions to the first tier tribunal, and accused the FTT, the first tier tribunal, of making decisions based on those secret submissions. And he was asked to apologise for saying that. He was sent material which the first tier tribunal said showed that what he was saying wasn't correct, but there had been one email that wasn't copied to him, but it didn't contain anything over and above what was in the letter that he had seen. And he didn't apologise, and in fact sort of doubled down on his allegations. So eventually he was reported to the BSB, and he was charged with a number of allegations about this conduct. And it was said that he'd breached Core Duty 5, i.e. not to act in a way which diminishes the trust and confidence the public places in the profession. And he was found to be guilty of two of the charges, which were related to what I just said about alleging that HMRC had been making secret submissions to the tribunal, and that the tribunal had been taking into account secret submissions. That was found proven, and that it was found proven that breached Core Duty 5, and he was fined £7,500 per charge, so £15,000 in total. And he appealed the disciplinary tribunal's decision to the administrative court, but they have upheld the tribunal's decision. So that's a case outside practice. I mean, obviously, it's worth noting that although it's conduct outside practice, acting in legal proceedings is something that barristers do. So although he was acting in person in that case, you can see why it seems obvious why that sort of conduct, even in your personal capacity, is so closely connected to the kind of work you do as a lawyer, that you can see why the BSB would think certainly that is something they should be dealing with.
Yeah, absolutely. And Andrew, have we seen any cases like that in the solicitor context?
Well, there was a case involving a city lawyer who was found by an employment tribunal to have discriminated against his nanny when he sacked her after finding out that she was pregnant. He was rebuked for that by the SRA. Now, that decision was prior to the Beth case. I don't know if that would have made any difference, but there was a bit of public outcry at the time. This is quite an old decision now, as to whether or not the SRA should have got involved in that case, but they found that the employment tribunal's judgment, a public finding that he'd actually failed to report as well to them, of a solicitor acting in that way did amount to conduct which diminished public trust and confidence in the profession. So a bit less obvious there compared to Chloe's case, considering this has got nothing to do with his practice. He wasn't. It was purely in relation to a domestic arrangement. He was only given a rebuke, obviously, which is towards the more mild end of the offences, of the sanctions. But still, you can see how conduct in your personal life could, if it results in a civil judgment or an employment tribunal judgment, that could still result in the SRA taking action.
And so, if we could sort of wrap up, Chloe, sort of drawing all of the cases together, during all of the discussions that we've had together, do you think that the Hickey case and the main case will they have any other sort of wider significance in relation to criminal offences committed outside of practice, or is it specific to the particular nature of the offence? How do you think the courts and the regulators will handle these kinds of issues going forward?
I think that they'll both apply in their own fields of where they're relevant. So I think the original line of cases, one of which is Main, Fleischmann and so on, will continue to apply in the cases in which they are relevant. So in particular cases of moral turpitude, so sexual misconduct cases, sexual offences and that sort of thing, or any other case, dishonesty cases, any other type of criminal offence where there's moral turpitude, so that has dishonesty as an element, or that has maybe recklessness as an element. So violent offences that have either an intentional or reckless element to them proven. Whereas I think the Hickey approach will be applied going forward to cases which are seen not to have the same or any moral turpitude. So cases that are essentially criminal offences, but that either involve essentially strict liability or negligence. So one example is the dangerous driving that we had in Hickey. I don't think it would be all cases of dangerous driving. I think the reason it was found, they emphasised, the judge in Hickey, for example, there was no drinking alcohol, there was no using of a phone or nothing else, because you can have cases of dangerous driving where it would be right to say that there is moral turpitude. So I don't think you can just do it on the nature of the offence. It's a combination of what was the offence and what were the facts of that offence. So there might be other criminal offences that have that could be proven on negligence or strict liability, where the Hickey approach would be more appropriate, like for example maybe other driving offences, but then there may be others where it would be a more appropriate precedent to look at, but I think that's the key. It's what level of, if any, moral turpitude is there, and how much does this particular offence worry us about someone practicing in this particular area. Worry us, by us I mean the court or the tribunal.
Yeah, or indeed the public, right? Is that what they'll be sort of
they're trying to predict or say how the public would feel or react to a person having committed that offence practicing in that particular profession.
Thank you. That's so interesting. So Chloe, thank you so much for joining us today. Really, as I said at the start, really grateful. Thanks, Andrew, for your brilliant insights to those cases. If you have any topics you'd like us to cover on future ReguLaw episodes, do let us know. And thanks very much for listening.